So now I would like to turn it over to Chair Thomas. Thanks.
Thank you for that introduction, and congratulations, Larry, on the Jan Brink Award and for your long and distinguished career in public service. Earlier this fall, FERC issued Order 2222, which opens markets up for the aggregation of distributed energy resources. And as in the spring, we were planning our content built around the theme evolving compensation and market mechanisms. This order caused our president, President Shalander, to break out in his favorite disco song, which is "You Dropped a Bomb on Me," which he has graciously offered to sing at the next in-person NARUC meeting. So we obviously had to adjust our agenda to respond to this new FERC order. So because it's a new FERC order, there's some questions we won't be able to get into in terms of interpretation and intent, or how this order operates in conjunction with other FERC orders because of the staff rule with respect to discussing pending matters. So it'll be just the facts, Sergeant Joe Friday would say. But we had two distinguished panelists to discuss this order who were involved in preparing it, Karin Herzfeld and David Kathan, who are no strangers to us in CEP, and indeed David has presented before. We're fortunate to have them today. Karin Herzfeld is an attorney advisor in the Office of General Counsel at the FERC. She focuses on electric market matters, including energy capacity and ancillary services market rules. She currently serves as a lead attorney and compliance coordinator for the Commission's electric storage and distributed energy resource rulemaking proceedings, like the one that resulted in 2222. Also presenting will be Dr. David Kathan. He's an economist with the Office of Energy Policy and Innovation at FERC. Dr. Kathan is just shy of 20 years at the Commission after over 20 years in energy consulting at FERC. Dr. Kathan worked on market design issues, including distributed energy resources, demand response, smart grid and storage. Dr. Kathan served as a lead project for several Commission rulemakings, including the recently ordered issue 2222 on distributed energy resource aggregation. If anyone has a question, please type it in the chat. We'll see if we can get to it, but keep in mind pending matters cannot be the subject of questions. We will get to those with other panelists. We just can't do that with these. And I would also note that all the panelist bios are posted on the webpage. And with that, I will turn it over to Karin for her presentation, or her joint presentation with David. Karin, are you here?
Yes, thank you for the introduction, Chair Thomas. Dave and I are happy to be here today to provide the FERC update on order number 2222, which enables the participation of distributed energy resource, or DER, aggregators in all organized wholesale electric markets. Of course, the usual disclaimer that any views we express here today are our own and do not necessarily represent the views of the Commission or of any commissioner. Next slide, please. So first, just starting with a little procedural background that led up to the issuance of this rule. So in November 2016, the Commission issued a notice of proposed rulemaking, and it proposed to require each regional transmission organization and independent system operator to revise its tariff to establish wholesale market rules accommodating the participation of both electric storage resources and DER aggregators. Then in February 2018, the Commission issued Order 841, which amended the regulations to remove barriers to the participation of storage resources in the capacity, energy, and ancillary service markets. The Commission explained when it issued that rule that it believed more information was needed with respect to the DER aggregation proposals. And so it did not take final action on those proposed reforms in that rule. Instead, the Commission created a new docket to continue exploring the proposed DER aggregation reforms, ultimately holding a technical conference later in 2018, and then in 2019 issuing data requests to the RTOs and ISOs to gather additional information in particular on interconnection issues. Next slide, please. So a summary of the rule at a high level: on September 17th, 2020, we issued Order 2222. And in the rule, the Commission found that the existing RTO ISO market rules are unjust and unreasonable because of certain barriers to DER aggregations participating in the markets. The Commission found that where these barriers exist, resources that are technically capable of providing services are precluded from competing with resources that are already participating in the markets, which reduces the efficiency of the markets and could lead an RTO or ISO to dispatch more expensive resources to meet its system needs. So the Commission found that by removing these barriers, the final rule would enhance competition in the markets and thereby ensure that the markets produce just and reasonable rates. Next. Moving on to the definition of DERs, Order 2222 defines a DER as any resource located on the distribution system, any subsystem thereof, or behind a customer meter. The Commission explained in the rule that this definition is intended to be technology neutral to ensure that any resource that is technically capable of providing wholesale services through aggregation will be able to do so. And the Commission explained that these resources may include, but are not limited to, resources that are in front of and behind the customer meter, electric storage resources, intermittent generation, distributed generation, demand response, energy efficiency, thermal storage, and electric vehicles and their supply equipment. Order 2222 also defined a DER aggregator broadly as the entity that aggregates one or more DERs for purposes of participating in the capacity, energy, or ancillary service markets. And the rule emphasized that the aggregator is the market participant, not the DER. And the aggregator is responsible for interfacing with the RTO or ISO and ensuring that its aggregation meets all the applicable performance and registration requirements. Next slide. So moving on to jurisdiction, which Mr. Mansuetti was discussing earlier, and I have to say thank you to him for commissioning that Law Journal article from 2015, because I have that article, that particular article, with notes and Post-its, and I've read it a few times, so thank you. With respect to Commission jurisdiction, the Federal Power Act authorizes the Commission to regulate the wholesale sale of electric energy and interstate commerce, including all rules, regulations, practices, or contracts affecting those wholesale rates. And with respect to the Commission's authority to issue regulations pertaining to DER aggregations, the Commission found its authority stems from both its jurisdiction over the wholesale sales by DER aggregators into the market and from its jurisdiction over practices affecting wholesale rates. Specifically, the Commission found that the sales of electric energy by DER aggregators into a market are wholesale sales subject to the Commission's jurisdiction, and that the sales into the market from aggregators of demand resources, such as demand response and energy efficiency, are practices that affect wholesale rates. And the Commission noted that the Supreme Court found that the Commission's regulation of demand response in wholesale markets met the affecting standard in the Federal Power Act with room to spare. And that was the EPSA v. FERC decision. So the Commission clarified that in this rule, it was only exercising jurisdiction over the sales by aggregators into the markets, and that an individual DER's participation in an aggregation would not cause the individual resource to become subject to requirements that apply to Commission jurisdictional public utilities. The Commission also recognized a vital role for the state and local regulators with respect to retail services and distribution system matters, including design, operations, power quality, reliability, and system costs. The Commission also emphasized that nothing in the final rule preempts the right of state and local authorities to regulate the safety and reliability of the distribution system. The Commission also declined, however, to include a mechanism for retail regulatory authorities to prohibit DERs from participating in the RTO ISO markets through aggregations, otherwise known as an opt-out, which had been included in a prior rulemaking, Order 719, with respect to demand response. And the Commission found in Order 2222 that it was not legally required to grant such an opt-out because it has exclusive jurisdiction over the wholesale markets and the criteria for participation in those markets, which includes the wholesale market rules for resources that are connected at or below distribution level voltages. The Commission explained that this decision was consistent with the Commission's similar decision not to include an opt-out in Order 841, which was upheld by the DC Circuit in July of this year. And so in evaluating whether to exercise its discretion to grant an opt-out, the Commission found that the benefits of allowing DER aggregators broader access to the wholesale market outweigh any policy considerations in favor of an opt-out. The Commission also acknowledged that retail regulatory authorities maintain the ability under their jurisdiction over retail programs to condition a DER's participation in a retail program on that resource not also participating in the RTO ISO markets. Or in other words, state and local authorities have the ability to prohibit dual participation. However, in recognition of the potentially greater burden that the final rule could place on smaller utility systems, the Commission was persuaded to provide a so-called opt-in mechanism for utilities that distribute 4 million megawatt hours or less per year. This is also similar to the existing opt-in for demand response aggregations. The Commission also declined to exercise jurisdiction over the interconnections of DERs to distribution facilities when that resource interconnects for the purpose of participating exclusively through an aggregation. And the Commission found that in these instances, state or local law should govern. And with that, I will turn it over to Dave for more discussion of the particular requirements in the rule.
Thank you, Karin. Next slide, please. I am going to talk more in specific about several key provisions that are included in Order number 2222. Several of them already been mentioned by Karin. I'm going to go in a little more detail. The first is that, as Karin indicated, the DER aggregator in Order 2222 is the market participant. It is the single point of RTO ISO contact. It will be responsible for managing, dispatching, metering, and settling the individual resources. So that also makes them a public utility if they do make sales of energy to the RTO ISO. And as a public utility under FERC rules, they are then subject to several requirements, which include filing for market-based rate authority, requiring to file electric quarterly reports, and other requirements. As far as a single point of contact to the RTO ISO, they will be the entity that will be subject to the metering and telemetry requirements that the RTO ISO places on resources. So individual resources themselves won't necessarily be subject to those metering and telemetry requirements, which can be quite costly. But nevertheless, the Commission felt that it was needed to provide RTOs and ISOs flexibility on whether to require metering and telemetry of individual resources, especially large resources, in order to provide sufficient visibility to assist the safe and operation of the grid. The order also requires that aggregations must be heterogeneous. And what we meant by that is that different resource types must be allowed and cannot be only one resource. And what was intended by that is that there can be, of that set of resources that Karin mentioned, they can be combined to provide a service that they're technically capable of providing. A good example would be on a single facility would be solar rooftops associated with distributed storage. That would be an example of a heterogeneous aggregation. But this would be across multiple facilities where you could have solar on certain facilities and you can have storage on other facilities. They can be combined in the aggregation to provide a firmer resource and provide the resource and be that is being scheduled. However, we are giving the flexibility to provide the requirement to have metering telemetry on individual DERs. I'm sorry, I skipped on that. The last item on this page is on minimum size requirements for DER aggregations. The commission specified that they can be no larger than 100 kilowatts. This matches the minimum size requirements we specified in order number 841 for electric storage resources, and also is the minimum size that is for demand response in most of the organized markets. The rule does not adopt a maximum size of a DER aggregation. Next slide, please. Similarly, the rule does not adopt a minimum or maximum size of the individual resources that can participate in aggregation. But each RTO and ISO must propose a maximum size for individual DERs. The commission believed that capping the maximum capacity size of an individual DER resource participating in aggregation would ensure that large resources are required to participate individually, thereby allowing RTOs and ISOs to independently model and verify the metering of these larger resources. Each RTO ISO must propose locational requirements that are as geographically broad as technically feasible, which may include multi-node aggregations. This was an issue that came up in a lot of conversation in our technical conference we held, but also in comments with how limited or how broad should the aggregations be, with arguments to be on just this one pricing node or one T&D interface, or whether it should be a broader across the various nodes, allowing for a larger aggregation and a broader set of resources that can participate. The commission did not come down definitively saying it had to be one way or the other, but it stated that it had to be geographically as broad as technically feasible. And when the RTOs and ISOs come in with the proposals, they need to be fully justified and so they can be determined to be just and reasonable. As Karin indicated, the RTOs and ISOs must allow dual participation in retail programs and allow DERs to provide multiple wholesale services. And they can create accounting and operational rules to avoid double payment. And Karin already noted that the recognition of the capabilities of state and local regulators to be able to condition a DER participation in a retail DER program on that resource, not also participating in the RTO ISO markets. Next slide, please. A major consideration and a major part of the order and an issue we heard a lot in the comments and at the technical conference was on the issue of coordination. And coordination of how, since distributed energy resources by definition exist on the distribution system, how will the operation of these resources integrate and coordinate with distribution system operation and also with wholesale system operation. So the order number 2222 sets forward several coordination requirements for the RTOs, ISOs develop as part of their market designs for DER aggregations. It must revise the tariff to establish market rules that address coordination between the RTO, ISO, the aggregator, distribution utilities, and state and local jurisdictions. It must incorporate a comprehensive and non-discriminatory process for timely review by a distribution utility of individual DERs that comprise a DER aggregation. And the timely review must be set at a reasonable period of time And the order specifies that it should not exceed 60 days. It's trying to provide sufficient time for the distribution utility to look at the individual DER and determine if there's any safety, reliability concerns, or there's any other capability issues associated with those resources to be able to participate. A major issue is what happens in real time. And the commission directed the establishment of a process for ongoing coordination, which happens during the operating day, so that if a aggregation is scheduled to perform in the operating day, but during that day there is an issue at the distribution system level, whether it's poles being knocked down or whether there's a transformer issues, that make it such that the DER cannot operate, cannot provide that resource as part of an aggregation. There needs to be set a process for communicating and for being able to address the change in the amount of resource can participate. And so there needs to be information from the utility to the aggregator and to the RTO ISO needs to be set up such that it can happen in real time, such that there is no safety and reliability issues at both the distribution and wholesale level. And finally, the commission directed that the RTOs develop a process that accommodates and incorporates voluntary state and local state and local jurisdictions involvement in the coordinating the participation of aggregations of DERs in RTO and ISO markets. These include, the commission felt there was an important role for state and local regulators in coordination, especially in setting rules at the distribution level and in the RTO ISO stakeholder discussions. So with that, that's the end of our presentation, and Karin and I are available to answer any questions. Thank you.
Thank you. Very briefly, we don't have questions on chat. Only one from me. What's our time frame, and how does that time frame relate to rehearing? Is it 270 days? What are the RTO ISO compliance deadlines for 2222?
Yeah, so the compliance deadline for the RTOs and ISOs to comply with the rule was 270 days after the publication in the Federal Register, which comes out to July 19th, 2021. Rehearing is pending now, obviously, so.
There's a lot of stakeholder work that will happen between now and then. Thank you, Karin and David, for your presentation. And with that, I will turn it over to Danielle.